Video 2 in the probate series with Yaz Adamy. Today we're talking about selling your inherited property.
So in order for property to be inherited, it has to first be transferred to that individual. So like probate would have to have already occurred.
Okay.
See what I'm saying? So like
Sure.
once the judge signs the order, that is now inherited property.
Okay.
Before he signs the order, it's maybe inherited, but we don't know yet because it's still in the dead person's name.
Gotcha.
So in order like to sell inherited property, okay, well, in order for it to truly be inherited, it has to be transferred to the heir.
Okay. So it either had to come from probate or it had to come from a different estate planning tool that you use.
Like a ladybird deed.
A ladybird deed. So what's a ladybird deed?
So a ladybird deed is a deed that the homeowner or the real property owner does when they're alive. And what the ladybird deed states, and it's a type of a life estate deed, but it's an enhanced life estate deed. And what it states is, hey, listen, I get to live here and do whatever I want with this property during my life, sell it, mortgage it, whatever. I don't need to ask, anyone else for that permission. But when I die, I want it to go to, Peter, Paul, and Mary. So then by way of deed law, when that person, the property owner dies because of that ladybird deed, there's no need to go to court. Okay. The property vests to Peter, Paul, and Mary. Okay. So it's an estate planning tool that avoids probate. It's an enhanced life estate deed, and Florida is one of the only states, I believe, that has this type of a special deed. Texas, I think, does as well. Okay. But the person, the homeowner, isn't giving up any of their rights. Under a normal life estate deed, like a plain vanilla life estate deed, they would have to ask the remainder beneficiary, so Peter, Paul, and Mary, they'd have to get their permission first to do anything.
To like mortgage it or something like that.
But and I mean, in all honesty, some lenders these days are requiring that, even though that's contrary to what the law says. But lenders, as you know, will do what they want.
They can do what they want.
They can do what they want. But how how that works is you don't really give up any of your rights. But then when you pass away, by operation of deed law, it goes to whomever you've listed as the remainder beneficiaries. Saves the family thousands of dollars of having to go to probate.
That makes sense. So how would I typically know if I was a beneficiary of a ladybird deed, or how would somebody know that?
Might not know. You don't need to sign anything. And here's the thing, and I'll explain why. So with a ladybird deed, let's say I own real property and I want to make sure that when I die, it goes to my sister. I'll go to a lawyer, have them draft up a ladybird deed, and I'm the one who signs it because I'm the grantor. Grantees never sign anything. They don't when it comes to deed law. What if I end up changing my mind, which I can, and I say, I don't like my sister anymore. I want her to get anything. I wanted to go to my brother. She never knew about it to begin with. Right. So then I can just go back to the lawyer and say, out with my sister, gone, put my brother on.
There you go.
Sister never signed anything to begin with, and I have the full ability during my lifetime to change whatever I want. Yeah. Now that is through a ladybird deed, the enhanced version. Under the plain vanilla one, she'd need to sign off. She'd need to know about it, because if I wanted to get her off and put my brother on under a normal plain vanilla life estate deed, she would have to sign off. Okay. But under the ladybird deed, which is it's a Florida, it really is very very well loved in Florida, because it's one of the cool things that we can do in this state.
Yeah. Well, it's nice. I mean, it sounds like it gives the rights to you to do what you want with your property while you're living, and then
absolutely. As you should be able to, right? Yeah. As you should be able to. So yeah, so that's why they're really, if I want to tell my sister, I can, but I'm not required to.
Yeah. So All right. So getting back to selling your inherited property. So if you, so you either went through probate and you know about that, you could be a recipient of a ladybird deed. You might not necessarily know about that. Is there any other way I could have received this inherited property?
So either you go through probate or through, no, when it comes to real property, no.
No.
I mean, the only other way is this, is if you are actually on the deed to begin with as a joint tenant with rights of survivorship.
Okay.
You're going to know about that. Like
You
you
would
should,
definitely know about that.
yeah, you know about that. So how that would work, and that's different
But
than a
that's less
tenant.
of, is that considered inherited or is that less of inherited? Is that more of,
It's not really inherited
yeah.
because you had a present interest.
Yeah,
It
that's
was
what,
your, like when you guys were co-owners.
sure, sure.
So it really isn't inherited.
Okay.
Um, but it's so like really with real property, those are the ways that it can end up getting, either probate or by operation of deed law. Those are the two ways that real property vests in someone. So
So,
then, yep.
so I've got the property from one of those two things. Now, how do I sell it? Can I sell it?
Time to go and meet with a realtor, right?
Well, I could definitely help them with that.
Yeah.
But what if things get messy? What if there's like 3 or 4 people that inherited property, like one wants to sell and 3 don't? What happens there?
So they don't, if, so let's say we've got 3 heirs who all by operation, I don't know, we'll say they all went to probate and now the property is in all 3 of their names, right?
Yeah.
Order says it goes to the 3 of them. It's the 3 of them. They don't like each other. Happens all the time. Right? One wants to sell, the other doesn't want to sell, and the other one doesn't care.
Yeah.
So best thing is to try to first come to an agreement between the parties, some type of a non-judicial settlement agreement where maybe one of them could buy out the others or something. If that does not work and they refuse to come to a non-court agreement, then off to court we go, and that is a partition proceeding. And those are expensive. My whole thing, and I always tell people this, if we can come to an agreement between, figure out an agreement between the parties without having to go back to court, you're going to save a lot of money, because whenever the court's involved, especially with litigation, and that is a bit of litigation.
Yeah.
It's going to, the people who win are the lawyers.
Yeah.
That it costs money that could certainly be saved by just coming to an agreement between the parties. And here's the thing, the partition proceeding is going to end up being very similar to what the parties could have just agreed to. You know what I mean? So it's
Right.
like, yeah, if we cannot come to an agreement, then it's off, a partition proceeding. And
then you go through litigation via partition. What did you say? Partition
so like,
proceeding, and then you get a judge to tell you what you should have just agreed to from the beginning and saved yourself a whole bunch of money.
Yep. And that's how it's going to go. The judge is most likely at that point going to say, okay, well then the property is going to be sold.
And that's where because I think I've seen an order to sell before or something like that. Is that where that comes from, or did I see it wrong?
Well, sometimes if we are, like, let's say there's property stuck in probate and we have to wait out a creditor period because the person hasn't been dead for 2 years, but it's a hot market and we want the ability to sell the property before the creditor period is over, I'll motion the court for the permission to sell it. And the proceeds will be held in my attorney, my Florida bar monitored trust account until the creditor period is over. And that's just to get the sale through. Partition proceeding is another time where, yeah, the court will order the property to be sold, say, agree, like say what the price is going to be. In that case, to be honest, with a partition proceeding, if there is an heir who would like to buy it, if they want to buy it for fair market value, I don't really see a court refusing them as long as it's fair market value. So really, if you truly, if your sibling is going to purchase the property for fair market value, just come to an agreement that is, an attorney drafted agreement without court involvement, and just figure it out, get it appraised, or get,
Right.
you know, to make sure that everybody knows what the fair market value is,
Yeah.
and go from there. There's partition proceedings are just, it is truly a, like a last resort. It happens because folks don't understand that they're gonna, a lot of the money that of their inheritance is just gonna get eaten away by attorney fees and court
Yeah.
costs. Anytime the court's involved, like probate's pretty straightforward. It's not litigation, but partition proceedings can get into litigation, and litigation's expensive, and it goes on forever and ever in the state of Florida. Cases languish. I don't litigate much at all anymore.
Yeah.
But when I did here, I mean, it's very common for cases to go on and on and on for years.
Wow.
One that we started in 2017 just closed. We finally settled it out, and it ended up settling out. So it's just like
all that fighting and then just to settle 4 years later.
So I'm like, litigation is definitely to be avoided at all costs.
No kidding.
I mean, it's nobody, I mean, lawyers win because they get to charge. But that is, just think, like, if a litigation case takes 1.5 to 2 years to end, that is 2 years of your life that you are stuck in that turmoil. And you're paying some lawyer to keep on going to court, filing, and it's each side tends to want to
so you're not only paying monetarily, you're paying emotionally too. That thing's
Absolutely.
hanging over your head for
Yep.
forever.
And it's so that is if the heirs don't agree on to sell it, and they cannot, whether to sell it or not sell it, or on the price, best thing is to first try to handle it through attorneys without getting the court involved.
Okay.
And then they still can't, then off to court, it's partition proceeding.
Gotcha.
Which is really partitioning, seeing what each person is entitled to. And I mean, the worst case of a partition proceeding is where they want to divide up property into separate little parcels, which usually that, unless you're talking about a decent amount of acreage, that's not going to happen. It's really the court ordering the sale and how those proceeds will be distributed.
Split up.
Mm-hmm.
Okay. So I guess to recap this one, selling inherited property, really what we needed to do was define what the inherited property was. And that basically meant we're already through probate, or there was a ladybird deed transfer. But once you have it, you can pretty much sell it however you want. And the only time it gets muddy is if there's some, maybe a few owners and one doesn't want to sell and things of that nature. And then that come to an agreement, or you're going to pay a lot of money and waste a lot of money in litigation. But just a quick answer, selling inherited property, once it's inherited, you can pretty much do what you want with it. Does that kind of wrap it up?
You got it. The one thing that I'd like to point out for realtors, and you know this, if there are multiple family members, have them all sign the listing agreement.
Yeah, definitely.
You don't want it to be where you end up having one sign and you go and find a buyer, and then there's another one that hired another realtor and you don't even know it. I mean, that has happened.
That's not good.
No, it's not good. And it's just make sure they all sign the listing agreement.
Yeah, definitely. Good pointer for all you realtors out there. Have everybody sign the listing agreement.